A very good morning to all of you and happy World IP Day. Though the situation is not that happy, but tough situations always produce something which is meaningful. And in our realm of intellectual property right, as you know, the innovations are always handy to meet the situation if they are done in a proper manner. So sometimes people are a little surprised that why intellectual property is being discussed in this very situation. I mean, in that way, that whether it has a negative impact or positive impact, whatever it may be. So every intellectual property right has some sort of, one can say, social purpose. So we are today exploring those social aspects through, by touching these two themes like COVID-19 pandemic, as well as the theme of the World IPD, that is Innovate for Green Future. So let me introduce, first of all, my panel. It's very enriched and diverse panel. So I must start with Professor James. Professor James is currently working with RIS, that is Research Information System for Developing Countries, and he is looking into various policy issues relating to medicine and other areas. And he has a very enriched experience in intellectual property law because he has been a director under the DIPC Ministry of you can say Commerce and Industry, and he has worked significantly on this very area by being a part of that discourse which has been responsible for some amendments in copyright, and he has written also for the ministry a book for the copyright, and he's grabbing various policy issues, what government is doing and how that is being grabbing various aspects. So in that sense, he will be catching up the policy issues within the realm of government, how that could be translated, how that could be revised or refined. So he must be touching from the policy perspective to our discussion. Now, next I will introduce Mr. Gopakumar. I can say professor also because he has very significant contribution in academics. So I have gone through your publications and I found that they are really, I mean, that is a very, very, you can say a game changer kind of thing. And Mr. Gopakumar is with Third World Network, where he is a legal advisor as well as senior researcher. So he's a great voice of developing countries, underdeveloped countries relating to access to medicine and many other things. And as well as he has also been a very, very prolific, you can say, participant in WIPO and WTO discussion forums where he has raised these issues very, I mean, you can say, significantly. So he will be touching upon the reality check, how the issues which remain on the paper very ideal. I mean, they are looking very perfect, but when you go and touch base with the society, you will find that there are certain gaps which needed to be fulfilled. So whether our understanding of IP laws there and the flexibility under it that is being provided under various laws, whether that is very, very perfect or there is a need to look into it and redefine it, or at least understand it, whether what we are understanding that is the same thing on the ground or not. So he would be instrumental in bringing that kind of reality check to this very intellectual property discourse, to what extent they are fulfilling the social purpose. And next, last, I will introduce my professor in charge, Professor Raman Mittal, who is also a very illustrious IP scholar, and he has a very, very enriched, you can say, experience in intellectual property law. He has been part of that DU photocopy case also. He has been, I mean, very, very substantially involved in that. Apart from that, he has been responsible for various intellectual property draft like copyright amendments and all that. And he is a very sincere, sober, and I must say a silent observer of the things, and then proceed in that realm a little, I mean, seriously in that way. So, and he's my senior colleague in that way. I'm a little affectionate in that way to him. And under his guidance, many things are being going on, and I hope that this is one of the initiatives which we are catching up. So after this very introduction, because you all three are speaking in a sequence, and that sequence I will start from Professor Raman. But before that, I must set the tune of this very discussion. I must, grab the topic and explain the topic and how we are going to, approach the topic that I must explain. So please allow me to do that. So let us, first of all, what is our topic? Why we have, decided to speak upon that. So the topic of our discussion today is COVID-19 pandemic and uh, green innovation, exploring social aspects of IPR on World IP Day. So what is my understanding of this very subject is that if you define property in any way, intellectual property has some sort of, you can say, distinction as compared to other properties. And in that way, if you take any example, all the intellectual property rights are based on state policy, and they are destined to promote the social good in one way or another. For example, if you take the example of patents, they are for the scientific and technological progress. And that scientific and technological progress is always destined to improve the life, to provide a kind of better life to the people, to provide, to solve the technological problems which are deeply rooted in the, social existence. So in that way, patent is also very much instrumental in that need. So that has a purpose, which is a social purpose. Likewise, copyright has also its purpose, that it is destined towards, promoting the creativity in the society, as well as trademark promotes the fair, practices in trade and protects the consumers in that way. So these are the illustrations where we can grab that every intellectual property right is, framed in a way that it looks pretty balanced, that it promotes, it incentivizes the inventor or creator. On the other hand, it is also taking care of the public good. But this very balance, which looks very, very prompt and very, very nice on the paper, is not being like that in the society. Why that is there? That is there because not of the framework more, but because of the practices of IP. So it is not only it is not because of the use of IP, but abuse of IP, which creates a lot of problem. And the other thing is that whether we are properly understanding the theme of the IP, their purpose, and whether we are aligned to that very purpose or not. It is a very emergent situation right now. We are encountering two calamities, like one is, to say, COVID-19 pandemic, as well as environmental problems. A few days back in Delhi, we were wearing a heavy mask to protect ourselves from the, pollution. And now there is another pandemic which is, creeping in, and it is being devastating the whole world. So this is a kind of alarm. We have to understand that what are our practices, whether they are sustainable to the human existence, they are sustainable to the social good, or they are taking a different line. So I must, put before you a trend which is going on right now. So you will be seeing the examples that many companies are being, just releasing their patent grab and allowing many other companies to join hand with them and fight for this very pandemic. There are patent pledges which are being made by the various companies in that manner. But this is an emergent situation, and everybody is just, trying to evade this very thing. But what about the normal situations? Whether in normal situations we behave in the same manner as we are behaving in the emergent situation? That is also a very important thing we have to understand. Because if we are practicing it properly, then this situation could not emerge. So I'm talking in a very, very wider sense, that if our practices relating to everything, if we practice the human existence, the various practices which are related to human existence in consonance with the environment, in consonance with the other fair practices, then this situation might not arise. So this day, we will be taking what is the common between these two themes. So if you take the COVID-19 or you take the green innovation, if you take the, catastrophe of environment, you will find that one thing is very common, and that thing is sustainable use of the resources, meaningful use of the resources, intelligent use of the resources, and promoting fair practices in this very realm. Otherwise, we will be encountering many situations like this. Number two is that how prepared we are, it is questionable. Many countries which claim that they are very developed, they are, I mean, dealing with everything very right, they are under the question mark. Why? Because we are always ill prepared for these calamities, because we are just lost in our own world, that these things may not come, or I mean, we will be dealing it, we can deal it in any way. So this is giving a lesson that these kind of catastrophes may arise, and one should be very prepared as regards to its all the mechanisms, may it be healthcare system, may it be intellectual property practices, may it be anything. So there are few instances which I must quote, and then I will open for the panelists. First thing is that there are certain, issues which are related to the IP assertion. So when we discuss about the social aspect, there is one dilemma which comes in mind, that if everything is being done for some philanthropic purpose, allowing the exemptions or exceptions, what about the innovation? Can we promote the innovation by just allowing the exemptions, or we need to evolve a different kind of model and channels which can promote a very balanced approach? For example, if you take a few days back, there was an issue that these tests which are being going on, they must be made free to all, when those who are not able to afford it, or not afford. So this very thing is a very tricky thing, and the situation warrants that we must have a serious discussion regarding that. That whether the startups or small companies which are devoting so much time, and their dedication is not questionable, whether they are being dealt with a different approach as compared to those giant companies which are just reaping the benefits, or they are very greedy and they are not doing that much as that is required. So this is a very, you can say, a balanced approach which must be exercised by having this examination on. So having said that, I think that I have set the tune of this very discussion, where we can start, with Professor Raman first, and Professor Raman will be discussing upon the jurisprudential basis of social aspect of IP, where he will be, presenting a kind of, you can say, explanation to various exceptions which are being recognized under intellectual property law, which enables us to grab the social issues. We are not going provision by provision because we don't have that much time. So we are just grabbing them in a more conceptual basis. So with these words, I must invite Professor Raman Mittal to take over from me. Thank you.
Thank you, Dr. Kshitij, for the introduction and for organizing this webinar. And I take this opportunity to welcome the other two panelists, Professor James and Dr. Gopakumar. And I hope that after about 15 minutes of our speeches, we will have enough time for discussion and deliberation and answering the questions of the participants, if there are any. Okay, so for this, for this webinar, I have prepared a small presentation. So let me just share the screen. Okay.
Yeah.
Now it's visible. The screen is visible.
Yes.
All of you. Okay. So the title of the presentation is "The Tao of Intellectual Property: Exploring the Social Aspects of Intellectual Property Rights." So if we see basically the whole intellectual property regime as captured in various statutes and common law that we have, what kind of interests do intellectual property cater to? Do the doctrine of intellectual property caters? So we find that the first set of interests is the owner's interest, the interest of the owner of intellectual property rights. And then within the same laws, within the same statutes, we also find there is room for, there is scope for, and there are provisions for competitors' interest, for guarding competitors' interest. And then a third type of interest that we see is the user's interest. So it is a mix, it is a matrix of combination of three sets of different interests which converge to form the doctrine of intellectual property of the present day. Now, the debate of intellectual property is normally stated like private interest versus public interest in various fora. So let me just state how I see this private interest and public interest, this dynamics. If we draw a circle and describe this circle as public interest, where would we draw private interest? My way of drawing is inside the public interest, because private interest lies in public interest. That the reason why I say so is because public interest is all encompassing. It captures all kind of interest, the owner's interest, the user's interest, as well as the competitor's interests. Normally they are pitched against each other. There is a reason for that also, but if we see it like this, then the problems will become easier to solve. That's what I feel. Okay, then the social, I'm talking in general about the social dimensions, not focusing on any provisions of any statutes in this regard. So in social dimensions, I would say these social dimensions are implicit in the balance of intellectual property right. The balance which is struck by intellectual property rights laws, they manifest themselves into the social dimensions. And this balance is struck by three aspects. First is the aspect of rights, then the second is the aspect of exceptions, and finally the third is the utilization or the licensing or assignment of intellectual property rights. So I tried to capture all these three briefly. So first, whether I'll start with trademark law, whether trademark law is property protection or consumer protection law. So the law itself, without going to the exceptions. So normally it is stated that it is property protection law. But let us for a moment go to the genesis of trademark law. There was a time when there was a consumer and there was only one supplier. Let us say supplier A. So at that time, there was no supplier other than A. There was only one supplier and the consumer. So trademarks was not required at that time. And then with the progression in the market, the supplier B comes on the scene. When supplier B comes on the scene, he's faced with a problem. Nobody recognizes, the consumer doesn't recognize him. So he masquerades himself as supplier A. When he masqueraded himself as supplier A and approached the consumer was willing to buy from him. He was sort of tricked to buy from supplier B. Now in this situation, in the absence of all trademark law at that time, what remedy the consumer had against the supplier B? I would say that supplier B always had the remedy in the tort of deceit, because supplier B was masquerading as supplier A. Now, the consumer always had this remedy, but then the consumer was never empowered enough to exercise that remedy. He was just not interested enough. Therefore, that gave birth to trademark law. The trademark law gave rights to supplier A to proceed directly against B without involving the consumer. Now, those who feel that trademark law gives rights to supplier A as against supplier B, they feel that trademark law is property protection law. And the second school of thought, which says that no, actually, the law wanted to protect the consumer, but because the consumer was not empowered enough, therefore the right was given to supplier A. Therefore, in the hindsight, the objective of trademark law is to protect the consumer and not to directly protect the supplier A. Now, there lies the social dimension of trademark law. For example, that the law which is called property protection is actually consumer protection law. It is meant, all the provisions are meant for the benefit of the consumer ultimately. Even though the rights have been given to the supplier A, it is for the benefit to be transferred to the consumer. And that is one aspect of the social dimension of intellectual property. Then we now come to the exceptions and limitations contained within the intellectual property doctrines. Now, the first thing here is, how do we represent those exceptions and rights? How do we represent the right and exception, and which came first, whether right or exception? So first of all, there was nothing, and then there came right. All right. If the red circle represents rights, how would and where would we draw exception. So in my understanding, exception would lie within the right, because exception takes a chunk from the right and grants it to the persons who are not owners of the right in the same domain. Now the next aspect is which came first, whether right came first or the exception came first. Now this is not necessarily a chicken and egg causality syndrome. Now I think that the exception came first, and there's a reason for that. Because if we see, when there was no right, the turf was all black, the color was black. Then came a right, and then came exception. But exception is always in the same color as that color of the background of the right. Therefore, that was always there. Before the right occupied that place, the exception was always there. So this is just to demonstrate the importance of exceptions and limitations which are contained within the intellectual property statutes. Okay, so next is intellectual property law is made up of rights and exceptions. So are they friends or are they enemies? So normally exceptions and limitations are pitched against the rights. But in reality, if we see deep down, they have a friendship. As the rights grow, the exceptions always grow. And it's difficult and impossible for rights to exist without exception, and for exception to exist, exception is just meaningless without the right. All right. Now, why exceptions and limitations? Intellectual property, just as physical property, can be limited to promote public interest. We have doctrines enough within the physical property realm which go to curtail the property aspect at the times of emergencies or at special situations or in general situations as well. Similarly, we have the same doctrines under different names within the intellectual property domain. Now, why those limitations and exceptions? First, it is vital. Those limitations and exceptions are vital to the creative environment. If we do not have those exceptions and limitations, the creativity, the ultimate goal of intellectual property, if we say, is to enhance the creativity in the society. So the exceptions and limitations really aid that creativity. They work as a tool to secure creative uses. They cater to the interests of access and making available the fruits of intellectual property. They are also many times an aid to exploitation of the works themselves. The exceptions and limitations facilitate new business models. And then we have constitutional values like free speech, free information, and availability of various products. Say, for example, availability of education and availability of drugs, availability of medical care, etc. So these exceptions and limitations seek to draw a balance and make these things available. And further, they seek to achieve the required sort of balance in the intellectual property domain. Now the question is, do exclusivity of rights and limitations of the rights have different goals to play, or they are complementary? I would say that they are complementary and they converge with each other, and they help achieve the same goals of intellectual property together. Now, one, the direction of law, which is growing, whether the rights are growing in our intellectual property system or the exceptions are growing. Now that's a very difficult question. It's not as simple as that. But I think that as the rights grow, the exceptions also grow within. The relationship between right and exception is like the relationship between yin and yang, day and night, male and female. So as the one aspect grows, second aspect grows as well, because we see the presence of one aspect within the second aspect, all encapsulated within a circle as well. So it's a dynamic relationship, of course. Now, let me quickly take the example from the copyright domain, the famous Delhi University photocopy case. So the case, as we all know, relates to those course packs which are being photocopied without paying any compensation or any royalty to the authors of the book, to the publishers. So case was filed in the Delhi High Court. We all know about that. So the issue was basically Section 14 of Copyright Act defines exhaustively the rights available in respect of books. Okay, so Section 52 is containing the exceptions to those rights. Now, the thing of course pack, the aspect of course pack is the decision whether the right over making course pack is within 14 or it lies within 52. That was precisely the court was asked to say. And the court stated that the right of making these course packs, of course, lies with 14 because exception is always within the right. But at the same time, it lies within 52 as well. So when it lies within 52, that is the exceptions to copyright, that means the Delhi University or Rameshwari photocopy service was well within its right to make photocopy and grant it to the, or give it to the students. All right. So the interpretation, this came by virtue of an interpretation of an exception that was contained within the copyright statute. The language of section 52(1)(I) was the reproduction of a work by a teacher or a pupil in the course of instruction. And the court found that the course of instruction, this expression course of instruction, could be used as a verb as well as a noun. When it is used as a process, a verb as a process, then it could harbor two kinds of interpretation, narrow interpretation and wider interpretation. And if we have a wider interpretation, then the reproduction or photocopying was permissible in the entire process of education, that is, for example, a semester. And if we consider course of instruction as a noun, then reproduction was permissible in the entire program of education, example, a semester. All right. So therefore, there are two interpretations of this expression, which the court found favors the defendants in this case. It favors the persons who were exercising this exception and limitation contained within the copyright statute. All right. Then the third aspect of the presentation is licenses. Now, basically, license is the major way through which all forms of intellectual property is exploited. Now, there are three types of licenses: voluntary, compulsory, and statutory. Now, this terminology is not uniformly applied across the countries and across the statutes. For example, in India, we have different statutes catering to intellectual property domain. So in those statutes, the understanding, the terminology used may have certain variations in this. Okay, so basically, exploitation of all intellectual property works could be in the form of self-exploitation and exploitation through others. And when it is exploited through others, it is mainly through the domain of licensing. And licenses could be voluntary, compulsory, statutory, and fair dealing. And fair dealing also I have put under license because though it is an exception, but this is very similar to a license. It goes very similar to a license. We say voluntary license is to be granted by the owner of intellectual property, and compulsory license is to be granted by the government, the state authorities. Statutory license is already granted by the statute, and fair dealing is also in the similar way granted already by the statute. The only difference between a statutory license and fair dealing is that for statutory license you need to pay royalty. At fair dealing there is no requirement of royalty. So self-exploitation and voluntary licensing, we say, is the rule, and compulsory, statutory, and fair dealing, they are exceptions. They come within the domain of exceptions and limitations. So this is in the nature of the exploitation of all intellectual property works in all the statutes. Well, some form of licensing may not be available in a particular statute. So this is another way of looking at it. So there are three kinds of licenses: compulsory, voluntary, and statutory. So this is the common area between compulsory and statutory license represents the non-owner exploitation by somebody else other than the owner of intellectual property. And the common area between voluntary and statutory licenses, there lies the orientation of rights. They are basically granted, they are for the benefit of the owner, voluntary and statutory licensing both. Now, compulsory and voluntary licenses, as I said earlier, they need to be granted either by the state or by the owner. The statutory license need not be granted because it has already been granted by the statute, subject to fulfillment of condition. And then all these three licenses are subject to the payment of remuneration. The goals of remuneration might differ from license, from the type of license to another. Sometimes the remuneration is nominal, sometimes it is compensatory, and sometimes it is voluntary, especially in case of voluntary, as much as you can negotiate. Okay. Then we come to an example from trademark jurisprudence. When in the beginning of trademark law, there was, it used to perform a single source function. That means the trademark basically told the consumers the source from where the goods were coming. But then when the advancement of trade and commerce, we came to the quality function. Now the trademark represented not only the source from where the goods are coming, it also became a representative of the quality. Once quality function was recognized by the statutes, because initially licensing was not permitted under trademark jurisprudence, licensing became permitted only when the quality function came by, when the trademark became a storehouse of quality. But then this allowance by the statute, by the law, was only in return of a guarantee. That guarantee was the quality. The guarantee is now in the statute that the licensing is permissible as long as the owner of the trademark ensures a steady flow of quality of goods. He should ensure same quality as of goods provided by the licensee as he has been providing. If he does not ensure that, or if he lacks in exercise of quality control, then the entire trademark can be expunged by on an application made by any member of the public. So here I say that even in the the social dimension is implicit within the main licensing provisions as well as in compulsory and statutory licensing. Okay, now we take an example from the copyright domain. Now, if there is no exercise of a license granted within 1 year, then the license or assignment could be deemed to have been lapsed. And if there is an insufficient exercise of the rights granted license, then the author can always complain for revocation of the licensing contract itself. So the social dimensions again are implicit within the licensing provisions and the remedies under those licenses within the copyright domain. And then we come to the patent area, and I'm sure the three panelists will speak extensively on the patents because that is really topical. The whole world is suffering from a disease, and we are looking for a cure, right? For the disease, for somebody to invent a cure. Now, we see that invention in the market dynamics, first, somebody has to come up with an idea to make an invention. And then he has to do some due diligence, whether other persons are progressing on the same path of discovering a drug then or not. Then extensive experimentation has to be done. Then testing on testing in lab, testing on animals, then human testing, and then you have to obtain drug approvals, and then only the drug can hit the market. So that's a difficult path for any discovery of drug. Now, sometimes it happens that at that stage, there is an entry of generic manufacturer who bypasses all that process of drug discovery and takes the final product. Or there are provisions like compulsory licenses and infringe and counterclaim provisions. So all these things, they seem to go to times who violate the patent law, patent rights of the proprietor of patent. But then there are enough flexibilities and for this mechanism. And in the recent past, we have seen in India these three important cases: NATCO versus Bayer, and Roche versus Cipla, and Novartis versus Union of India, which has given a very strong message to the world that in India we are capable of exercising the exceptions and limitations to the patent regime for the ban if the public interest demands so. So whenever there is a call of social interest or public interest, the intellectual property contains within itself, within its own domain, various provisions which can be. So I come to the end of my presentation now. So I just like to recite this small part from the poem that I wrote a few years back. Owning and sharing must go hand in hand for expression, for invention, and also for that famous brand. Striking this balance is like playing with glass. Delicate it remains even for the men of class. So basically, what we are seeking is to strike a balance. And if we are able to make a balance, then only the social aspects of intellectual property would be fulfilled. I'd like to end with a poem from years back, a small book. What he says is, stretch a bow to the very full, and you will wish you had stopped in time. Temper a sword to its very sharpest, and the edge will not last long. So basically, if you expand the rights to the full, then the system will collapse. If you temper the rights to be very sharp like a sword, then the edge of those rights will have to wither away. Therefore, rights and exceptions go hand in hand, and once they go hand in hand, and if we are able to make a balance, then only the social dimensions of intellectual property are captured. So thank you so much for the presentation, and now can you take over now?
Yeah.
Yes.
Okay.
Am I audible?
Yeah, yeah,
Kshitij?
you are audible. And it's a very beautiful presentation on the jurisprudential aspect. I mean, if I can say that without limit, you cannot put anything in proper say. Likewise, without exception, you cannot give intellectual property rights a proper say. And as you rightly mentioned that, you have, emphasized upon that exceptions come within the realm of right, then the questions comes in that very sphere that whether those people who are exercising their right, whether they are judiciously exercising that right or they are exercising it without taking care of the exceptions. Exceptions impose a kind of social responsibility also on a particular individual. May he be an inventor, a patent holder, may he be a copyright holder, that whether he is exercising his or her right properly or not. So as you rightly mentioned that all the things exist in that balance, but sometimes that balance is being carried away by these practices and the citation of these you can say well looking or nicely looking drafts which contain these exceptions. But sometimes these exceptions are not coming in that way meaningfully on the ground if you try to exercise it. For example, that is a voluntary licensing, everything depends upon that right holder, how he exercises his right. So in many cases, you have to apply the compulsory licensing also, so that that very autonomy of that very person may be checked in. So both the things are there, that the limits are properly there, but I hope that the main thing will be with those people who are exercising that intellectual property right, that they take it very responsibly. So having said that, it was a very, very beautiful and insightful presentation which has been made by you, and I hope that it has given various dimensions of intellectual property rights with the social aspect. So now I will be inviting Professor P.C. James, and because he is dealing with the medicine also, traditional medicine, alternative medicine, and pharmaceutical sector also he has grabbed. So I must emphasize that he must contextualize this very debate, because we have a very good jurisprudential base. Now we have to contextualize what is happening right now. So with both the aspects like COVID-19 pandemic, as well as with respect to the green technology, what are the challenges and how the policy makers are going through it, and whether there are loopholes, whether they could be checked, or whether there has been attempt to check it, and if that is so, then to what extent they were, successful. So with these, things in mind, I invite Professor James to take. Thank you.
Thank you, Dr. Kshitij, and a very good morning to my respected co-panelists and the participants. Professor Mittal has already made the background of the social dimension of intellectual property rights and how it is to be. And the good thing which has come out of the COVID-19 outbreak, if I look at from it, is that increasingly policymakers in the developed world are realizing this social dimension, which they were resisting for long. Although in 2002, there was a kind of limited realization during the SARS epidemic. Now we are back to it, and most countries are realizing it. That I will be explaining during the course of this. My presentation will cover two areas, as Dr. Kshitij mentioned. First, I will look into the policy aspects and areas of possible interventions by government. The second aspect will be the current IP Day's theme, that is green technology and how to go about it, the salience of that. To come to the first theme, the policy aspects, well, I earlier mentioned the social dimension they realized, but COVID-19 has thrown up major challenges for all aspects of economy and society, and of which intellectual property rights come to play a major role in the matter of healthcare and pharmaceuticals. The government's responsibility is to provide affordable access to safe medical products. That's the responsibility of any government, I would put it like that. Now, the World Health Organization or WHO's coronavirus treatment protocol has got a lengthy list of products that are needed at different stages of disease outbreak. That includes the low-end technologies like the gloves or the masks, which Dr. Kshitij was referring to. Then slightly better personal protection equipments, which the healthcare workers were demanding, protective gears, then high-end diagnostic kits, ventilators, and all those things, apart from medicines. Now, what really is the policy challenge? It is ensuring that these products are available there. But there are some issues thrown up by the COVID-19 epidemic. Mainly three of them are there. One is there is a sudden scarcity and global. There is supply chain disruption, so that even if it is there somewhere, it cannot reach the destination. Third, closure of manufacturing units in most of the countries which were in the forefront of healthcare and pharmaceuticals. Now, this impact has aggravated mainly because of an economic reason. For the last 2 decades, we have been in the global economy part. Global supply chain matrix is what economists were always arguing for, improving quality as well as reducing the price and all those things. But when there is a sudden high, I would say rather unprecedented global demand, the whole thing got disturbed. I mean, even WTO, World Trade Organization itself, says that the global trade of COVID-19 related medicines and medical products, only COVID-19 related medicines and medical products, is around 597 billion US dollars. So you know how serious that is. Now, if you look into these things, there's one aspect which is pure economics, that is demand supply formula. As any student who has learned the preliminary of any economics, they know that when demand goes up and supply is reduced, the highest bidder gets the maximum products. Now, why I mentioned this is, there was a report in the Washington Post that the developed countries, the US and European Union, they were getting all immediate supplies, and developing countries are put in the waiting line, waiting queue for these products. And that's one aspect governments will have to look into. But I will not go into the IPR, the economics and trade, more into the IPR. Intellectual property rights has got 2 dimensions in this case. One, of course, is that of the rights, and the second, the kind of conditionalities or exceptions and other things. We'll see how it is there. Now, let's take some examples. The intellectual property rights, they cover a large span of number of products. Now, practically, there's nothing which is outside it. And take the case of diagnostic kits, which is somewhere coming more in the middle range. Now, there's one case, which I came across recently. Roche, a Swiss multinational, they have the patent for the chemical formula for a reagent. That's a buffer used in the polymerase chain reaction based test for COVID-19. And Italy was facing a shortage. Roche was not able to supply even to that country, although Roche is there in Switzerland or to Netherlands. At the same time, they were not prepared to share the formula, which is a patented one. How to go about it? Another case, the high-end ventilators. Now, a ventilator is not one patent protected. Thousands of patents go into one single ventilator, depending on what it is. There are several parts. Now, if a part is damaged, it will not work. So, this Surgical, it's a UK-based MNC. They have patent for many ventilators, but due to COVID, they were not able to supply spare parts. One, they were not able to continue the manufacture. Now, countries have the technologies. To reverse engineering, they can find it. In Italy, a local firm, they made 3D copies of spare parts, 3D printing. And you know what was the cost? $1, O-N-E, 1, as against the original price by Surgical of $11,000. How do you deal with that situation? In both the instances, IP rights come into play. Now, coming to the medicines, many drugs are touted as either preventive or curative medicines. Although there is no definite view from any medical, whether it's ICMR or WHO. But these things go on spreading among the health personnel. For example, hydrochloroquine, which we read in the newspapers, India was supplying it because US was putting it as the medicine for COVID-19. Or many of the multinationals prefer, and they are already on that kind of clinical trial, they say, for favipiravir, remdesivir, etc., which are already used for other diseases. They are protected by patents, unlike hydrochloroquine. If original suppliers are not, companies are not able to provide, what should countries do? If, only if these medicines prove to be a medicine. So far, there's no proof on that. And if they don't relax their patent rights, how to go about it? That is where what Professor Mittal mentioned about the exceptions. So what are patent rights? What is generally known as the flexibilities ingrained in the agreement on trade-related intellectual property rights, of which the most famous one is the compulsory license, which in patent law is an authorization by a national government or an authority permitting a third party to make or use a patented product or process without the voluntary consent of the patent holder. Now, I of course mentioned TRIPS agreement, which is of 1994. But this provision was there from the very beginning. The Paris Convention for the Protection of Industrial Property is the first international law and agreement on intellectual property rights, that is of 1883. If you ever open that treaty, you will find in Article 5, within bracket 2, the same provision. The grant of compulsory licenses to prevent the abuses which might result from the exercise of the exclusive rights conferred by the patent. So it is not something totally new. This is what's called, what Professor Mittal referred to as the balance of rights and privileges. So this has been, a provision has been there, which of course was reiterated quite a lot, although even Paris Convention itself is the part of the TRIPS agreement, but TRIPS agreement also made very specific clarifications. But what happens is, when a national government attempts to do something, the big particularly pharmaceutical companies, they come into the picture. They dictate the international discourse. They do a lot of lobbying. This is what exactly happened in the year 1998 to 2000. Then countries, the governments had to reassemble. The TRIPS ministerial, they reassembled, and through the Doha Declaration on the TRIPS Agreement and Public Health of 2001, they stated unequivocally, I would say, I don't find a precedent in any other international agreement to this thing, where they made it very clear, each member has the right to grant compulsory licenses. Now, this is an answer to one of the questions posed by Professor Mittal, whether it's a right or an exception. The Doha Declaration made it clear that each member has the right to grant compulsory licenses and the freedom to determine the grounds upon which such licenses are granted. So, of course, and they mentioned some examples that included viral things like HIV/AIDS, then, of course, tuberculosis, of which India has the largest number in the world, malaria, again, we are leading in the world, and other epidemics like circumstances. So made it very clear. So that international instrument is very much there for the governments to act upon. Now the Indian Patents Act, we have our own provisions on compulsory license, starting with section 84 to 92. So detailed, this is with all conditionalities. And section 84 says that it has to be on the request of a third party. It has to satisfy the conditions that it be made only after a expiry of 3 years. Now, what will happen to Remifil? I will come back to that thing later. And should also satisfy at least one of the conditions, that reasonable requirements of the public with respect to the patented invention have not been satisfied, or the patented invention is not available to the public at a reasonably affordable price. So and it's not worked within the territory of the country. These are some of the provisions which were normally under attack by the multinational firms all along. Now there is a section 92, which provides suo motu rights to the government to grant compulsory license if government declares that there's a national emergency or an extreme emergency, or in case of public non-commercial use. So our law also has the provisions, and already Professor Mittal referred to the one and only compulsory license ever issued by this country, which had a patent law from 1856 onwards. Even before an international instrument, India had a patent law 1856, and even then till 2020, it has issued only one compulsory license for a drug, and that was the case referred to earlier. And I don't get into that thing, but that was a simple thing, was NATCO was to pay a royalty as per the final audits of IPAB, which are upheld by the Supreme Court and High Court, is 7%. So it is not a free for them. And they were to charge only a price of 8,800 against what the Bayer Corporation was charging, 2.8 lakh rupees. So, I mean, why I mentioned the Italian case of $1 and $11,000 is just to bring out how companies and, well, they discourse the papers and other things which come out of all these things, they get into these things. So, I will not dwell too much on the licensing part, I mean, compulsory license, but there are, I mean, some countries, let me just make it clear, while India didn't issue any compulsory license for COVID, at least as per the reports with me, there are 3 countries who issued compulsory licenses. One, of course, is China, which they consider not very this thing. Second one is Israel, which belongs to the European group of WHO, and the darling of our countries, Germany. Germany issued last also a compulsory license in July 2017. But you won't read about these licenses much because they are developed countries. Now let me come to, there are certain other provisions. Article 73 of the TRIPS agreement, that is towards the end, it provides security exceptions. And health security is a security. It is more significant and important than territorial security. Another aspect I want to just touch upon is evergreen. Another criticism of Indian patent law, section 3D, which you always come across. I earlier referred to these two cases where some trials are going on, Favipiravir and Remdesivir. Now, suppose, it's a big supposition, suppose they come out that through clinical trials, they can be used for COVID. The companies will immediately apply for a new patent for that, evergreening, because they say it is a new use. Now, of course, it will be depending on the patent examiner to consider, as per the Indian patent law, whether it increases the therapeutic efficacy. Companies definitely will argue it is for a new disease. So this is a question, this is a provision which is likely to come up in this thing, and which government may have to take a call on that. Another provision which is constantly being attacked by all these pharma companies is Section 83, working of the patents. In fact, they are already criticizing why the patent office is asking for the working of the patent, these things. But when trade is getting disrupted, what will you do? And then, of course, I should just mention few government initiatives are there to encourage innovation, but like speedy examination of Indian startups, reduced fee, patent facilitation centers, and etc. etc. But that's not very significant for this one. Now, let me come to the second topic, green future. This again has come to the forefront, green future. COVID has made policymakers and academics to think about it. Earlier, we had, of course, the Sustainable Development Goals and the Paris Agreement. But the increasing number of pandemic was a thinking among people that everything is not all right with the development model that we have, which I call Western model of capitalism. That environmental damages may be a cause of these epidemics and emergence of new ones, that COVID-19 may be the latest one, but definitely not the last one. In fact, I do remember Professor Jonathan Mann of Harvard, he is heading the School of Public Health. He mentioned even in 1995, the history of our time will be marked by recurrent eruptions of newly discovered diseases. Thereafter, 3 new viral diseases had come into the world, and COVID-19 is only the latest of these things. So the green future is a major these things. Now here, what can be done? 2 options. This is nothing really IPR, but one is reduce the demands or your requirements and go for the essentials, what I would call the Gandhian way of looking at it. The other one is looking for technological solutions, and that is where intellectual property rights come into this thing. And anyway, more believe technology brought the problem, and therefore technology should bring the solution. And the moment you talk about technology, the discourse moves over to innovations, and because in international discourse, innovation and IPR are symbiotically linked. Now, the way I look at it, innovation is a step beyond invention. It's a step to bring the fruits of science to the marketplace, and then the relationship can be easily understood. This is where discussions about clean energy, environmentally sustainable technology, etc. emerge. Practical of current concepts of progress results in increasing consumption of energy. You think of any machine, think of your own homes, how much energy consumption is. I mean, again, remember, as an author has written, prosperity brings its own, prosperity is a scourge of the powerful because it feeds on insatiable greed.
Thank you.
And that's where. So second and third industrial revolutions were based on that. Result, threats to climate change, environmental degradation. Now everyone is talking about low carbon technology concept and other things. And the National Environment Policy 2006 also talks about these things. And of course, I have some this thing. The slight difference between the two. Clean technologies minimize generation of waste streams in the production process and utilize waste from other consumption goods and productive goods. So it is the one step more than just merely clean energy. This thing. And yeah, it's coming to the conclusion. So, but there are certain barriers of adoption of these things. There are 5 barriers. I have 3 barriers. One, of course, is the strong patent regime held by many. And then second, the development of independent technologies is not feasible as per patents. That is the major problem. And the WTO regime, we faced this problem when we went for tendering of solar panels. So these are all related issues. And to come to this thing, I have a few suggestions before I conclude. Give me 1.5 minutes more. First is the conventional solution that IP advocates always argue for, that is expeditious grant of patents for green technologies. Not bad, that is a good thing, and that may help the entrepreneurs. Second one, which is more important, is more R&D. This requires significant government funding, and the examples are US, European Union, and China, of course. I mean, let me show you the 2 books. One is The Truth About the Drug Companies. The second one is The Entrepreneurial State. In both these books, you will come across where the government has been there. R&D, fundamental R&D has been by the public funds, by the government investments, and only at the final stage, innovation stage, private companies come into the picture. So on that thing. And then the third is, which is more fundamental, I would prefer a paradigm change in the approach to public research and IP rights. When public money is going to these things, should it not be open? Should the inventions not be open? Or at least make it available at a very low cost? A fourth thing, we are totally forgetting when we are talking about environment, the traditional knowledge related with that. There's no time to go deep into that thing. But the fifth one is about, which is again more fundamental. I know other professors are there. We know patentability criteria, 3 things: novelty, inventiveness, and industrial application. My suggestion is, why not think of a 4th criterion in the COVID-19 times, and environmental hazard? Why not say the technology has to be green? That is the meaning, technology that adds to carbon footprint or causes environmental degradation is not patentable. So I leave you with that thought, and thank you. And sorry for taking 5 minutes extra. Thank you.
It's well in line with what Professor Raman has said. And you have very clearly, defined that how the structural changes could be made to, respond to this very situation. And because we have paucity of time, so I'm not dealing that much on my own. I'm just, inviting Mr. Gopakumar. I hope you are listening me. And hello.
Hello. Yeah, can you hear me?
Yeah. So I'm just, inviting you to come and speak upon few of the points. First, you, introduce your third world network, what it is doing, and then the things which are being painted that these are exceptions or something like that. I have gone through some of your papers, which are very, very, well articulated. That whether these exceptions which are being there are meaningful in dealing with these kind of situations like COVID-19 or green technology, and how you think that what could be the better strategy, whether there is a need for a policy change or something at the international level, for these kind of situations, meet these kind of situations. And number 2 is there is something which is being going on the funding issue, like whether WIPO should be there or WTO should be there or not, or whether their role is totally impartial or it is being pressurized by someone else. Those who are pressurizing are now questioning that you are impartial or something like that. So give a little bit insight about that also. So over to you.
Yeah, thank you, Kshitij. So I'll start with the COVID-19. So intellectual property is discussed in the COVID-19 context uh, mainly from an access perspective uh, as well as from an innovation perspective. So let us take up the first thing on access issues. As Professor James already mentioned to you that COVID-19 also poses a unprecedented challenge for the intellectual property regime. Normally, when it comes to access and intellectual property debate or discourse, normally we conceive access questions in the context of patents, especially in our past experience of HIV, access to HIV medicines or access to cancer medicines. So the idea of access is always very much connected to the patent rights. We don't look at the access issues that much with trade secrets or IP protection or even copyright. Copyright we do discuss in terms of access to knowledge or access to educational material. But the COVID-19, the intellectual property rights across the board poses access challenges, which affects our response to COVID-19. So we need software codes, we need trade to tamper with some of the medical devices, including ventilators or even scanners, etc., to make it use, make its efficiency or to reverse engineer some of these parts to enhance the local production. Similarly, we need trade secrets. Some of them are protected, especially in the case of diagnostics, or even when we use the artificial intelligence or big data for some of the COVID to develop some of the apps related to COVID-19. So we need a lot of intellectual property rights to mount an effective response to COVID-19. Once we try to do that, intellectual property may come in all these forms of intellectual property may pose a challenge. So therefore, what will we do? Most of our flexibilities debate, as I mentioned to you, is in the context of patents, right? Our tools also, by and large, is in the context of patents. You have compulsory licenses. We never talked about a compulsory license in the context of copyright to ensure public health, right? We do have our provision in our Copyright Act mainly to enable the textbooks, okay? Or we can reverse engineer the software only to achieve interoperability. But if you completely copy the software without the permission, then that becomes a piracy. So these are the issues. Then how will we do that? So the current intellectual property regime needs or current our response or mindset needs a change. So first thing is that we need to understand that we need a range of intellectual property rights to make an effective intervention in the context of COVID-19. What are these interventions? One is to seek these, take these technologies to promote local production, or even you import from a cheaper sources, then it might be protected in your country. So you need these intellectual property barriers needs to be navigated or bypassed. So how will you do that? Most of our national laws are not equipped to deal with this whole range of IP. Patents, of course, when it comes to medicines or vaccine, you can always use the compulsory licenses or government use license. But what happens when it comes to copyright or even a trade secret uh, or designs, industrial design? So in that context, I think the South Center's suggestion is a worthwhile to note. South Center basically told not countries directly, but the DGs of Director Generals of WIPO, WHO, WTO, and UN Secretary General. So a letter the South Center asked them to encourage countries to make use of Article 73 of the TRIPS agreement. That's a security exception. So in the case of security exception, you can do away with the IP protection. So that basically means you can either suspend the intellectual property protection to facilitate COVID intervention, or you can suspend the enforcement of intellectual property for COVID response. So what is Article 73 of the TRIPS agreement? Article 73 is actually borrowed from Article 21 of the GATT agreement. It basically says that nothing in the agreement shall be applicable to require a member either to furnish any kind of disclosure requirement. The example, for example, is that okay, in the case of atomic energy, or national security, we can withhold the publication of the patent application. But the most important thing is that Article 21B of the GATT agreement or Article 73B of the TRIPS agreement, which basically telling countries not to they have the freedom to do away with the TRIPS agreement or suspend the TRIPS agreement, mainly in the security aspect. But there is a word called other emergencies in international law. The actions taken the time of war or other emergencies of international law. And 73 says, he says that to prevent members from taking any action in pursuance of its obligation under the United Nations Charter. So in these two contexts, you can suspend the agreement. But again, the problem is that ultimately, if you want to invoke 73 provisions should be in our intellectual property law. If you look at the Article 73, whether it is incorporated in our patent law, we do have patent law, we don't find the same sentences, okay? But there is some public health emergencies conceived in Section 92, and government use is there. But when we come to Copyright Act, we don't find anything like a security exception. But we do have security exception, the similar language like taken at the time of war or other emergency of international relations. You will find it in Designs Act and IC Act, okay? Design Act, the controller has the powers to cancel the registration. Okay, similarly on IC, but we don't have it in the Copyright Act, or we don't find it exactly similar way in the Patent Act. What is the advantage of this? This act cut short all the procedures. Okay, you are suspending it. Okay, but if you go for a government use, you have to specify the compulsory license, the patent. You have to authorize somebody, a few actors to do that, or a government agency to make use of those patents. If you suspend it, or if you suspend the enforcement, anybody who has the capability can make use of these flexibilities, and it can be used for access. So then, what should we do then? I would say that the TRIPS agreement, Article 73 is a good provision, but we do have operational problems in making use of it. I would then suggest that we should probably go for a waiver of the TRIPS obligation under Article 9 of the agreement establishing WTO agreement. We should ask for a waiving of the obligation. Waiving is a temporary suspension of the obligation. There are many provisions in the WTO agreements have been suspended or waived at different point of time. So similarly, we should seek a waiver. So having said this, then intellectual property also poses challenge in innovation framework. So we know that okay, we don't have an effective vaccine, we don't have a new medicine, so we are yet to achieve much more and more accuracy in terms of test kits. What happens if you go by the without hurting the intellectual property paradigm? Then people will keep this result outcome to protect the IP, and then only they will make publish. So then we are running against time in our fight on COVID, right? So we need an accelerated approach. So for that we need sharing. So I think I'll take 2 more minutes and stop it. So in that context, also intellectual property need to move away from an intellectual property driven R&D approach to much more an open R&D approach, an open innovation paradigm where people across the globe share and you identify the knowledge gap, and immediately then you go for open peer reviewing, identifying the problems, and then you find the solution. So that will accelerate the product development much more easy and much more open way, much more stronger than the closed approach, driven by the intellectual property right. So keeping these two things which I mentioned in mind, now just look at what the international organizations are doing. So international organizations, the UN already adopted 2 resolutions on COVID, and the last resolution basically asking, empowering the UN Secretary General to take measures along the member state to ramp up the production. How to ramp up? You can also again go for an open manufacturing. You can put property there, you put the know-how there, you put the all information which facilitate the manufacturing. So the people who have the capability can immediately start the production, right? Then the second, the WHO and WTO made a joint declaration. So they are wishy-washy in many things, but they do give a call for sharing of openly sharing intellectual property rights. So you are basically saying that you share the intellectual property, so you can go for a much more an open innovation. And lastly, the WIPO basically came out with a WIPO DG came out with a declaration. He do recognize that you can make use of the exceptions and limitations, including compulsory licenses, to address the access problem. Okay, but innovation, WIPO has listed a certain activities. I am not going to comment right now, but that's not very helpful at this stage because IP slows down the process of innovation, slows down the speed of innovation. So basically, I'm concluding by saying that what we require at this moment is then moving away from the IP paradigm. First, to access the product, and second, to accelerate the process of innovation. And WHO also recently set up an accelerator, COVID product accelerator program to ensure much more innovation, speed up the innovation in a much more sharing way, and much more of speed up the dissemination of these technologies. So let me stop it here. Thank you.
Thank you very much. And we have just 5 minutes left. Yes, sir. Are you? I am summing it up. What comes from all of you, and then we will be. There are 2 questions there. One is related to if there is one student who asked last night one question. He sent me that whether how accessibility will be possible for the treatment of COVID-19, and if it is developed, then will everyone be vaccinated? And if everyone would be vaccinated, then who will bear the burden? So this is one of the questions which came, and another question was more, about the information, that is how Harvard online IPR course or Penn online IPR course is good enough. So I'm not sure whether all of you are aware of it or not, but if you have any sense, any kind of information you can give. Before that, I will just take 2 minutes to conclude what we have discussed, then we will go through it. So first thing is, the major takeaways from this is that there are certain situations, there are certain sectors, there are certain areas where you need to explore other models, other viable models, may it be like open model, or you can say open and collaborative model, for doing some research, for making certain inventions, keeping it open for something that is fair enough. But as a whole, you cannot replace intellectual property by just opening everything for everything. So the thing is that the things which are so important, as the very important area is medicine. So when it comes to essential medicines, when it comes to these kind of situations which we are dealing with, open and collaborative model must be adopted, and there are some silver lines which we are seeing for you can say in a very temporary manner, where there are certain companies which are coming up, and they are making patent pledges, as I said, that we are opening our inventions to be used for other, to produce other inventions. And various universities as well as various companies, they are joining hand to do that. But the problem and the issue is that whether that is sustainable for a long time or this is only for the emergent situation. So that is a question which we have to look into. So what comes from everyone is that differential approach is always required, and we need to explore the scope of the exceptions more, and we must be resilient in adopting that, number one. Number two, we have to understand the practical realities also. Who is governing and who is, taking care of, who is the inventor and for whom the invention is being made. That is also a kind of thing which must be paid heed. And the third thing is, regarding the green innovation, there are so many examples. Like if you take example of patent, you can go for the green technologies or eco-friendly technologies by allowing some non-exclusive licensing, open licensing to enable that. And if you take the example of trademark, you can use some sort of prefix or suffix like eco, enviro, where you can promote these kind of stuffs. Likewise, by recycled product or something, you can take that very discourse in the realm of design. So everything is possible if that could be done in that way. So I'm just, leaving to you for the final comments. And I don't think that there is a 5 minutes, so we will have to manage that. So let's see. Yeah. Over to you. Any of you, if you wish to answer the questions which are raised by a few of the participants, then it is good.
So, may I?
Yeah.
Yeah, I think, apart from what I mentioned, I just want to say that apart from the COVID context, COVID also raises other concerns, like, now most of the classes have been moved to online format and all. So we may need to make use of much more, digital and creative work to violate copyrights, actually, to make, hard copies of books into digital reading and also in the education purpose also, the IP challenges may come up. And having said this, there is one more issue what we also come across. Am I audible?
Yes.
Yeah.
Hello?
Yeah, you are audible.
Hello?
Yeah, you are audible.
Audible. Go ahead.
Am I audible?
Yeah.
One more issue. One more issue I have not mentioned earlier is the access and benefit sharing. So the sharing of the virus is very important for any kind of COVID response. But is it free sharing? And the companies or whoever develops these products are not being shared with the people who shares the virus, then there is a problem. Okay, then it also creates a violation of international obligations on biodiversity. So we need to have a fair sharing of benefits in a fair and equitable manner. So it's a mutually give and take situation. The virus samples are very important, and at the same time, it should not be used only for developing products and not retaining the benefits. So it is also important to underline the importance of benefit sharing. So let me stop.
So there is another question which pop up. We must, take 30 seconds to respond. That is, to what extent the ownership rights of IP could be exercised if it comes to the purpose of IP. So one of you, if you wish, you can.
Okay, so may I?
Yeah, please.
Okay, so let me respond to this question: how to rationalize ownership and the purpose of intellectual property. I don't think that they are opposite, which I mentioned in my presentation as well. So the purpose of intellectual property is to facilitate the creation of more and more intellectual products. And once we are able to create more and more, then comes the question of the utilization, the dissemination, the distribution of those created resources amongst the people. So first of all, we grant ownership so that the person who makes an investment in the creative activity is guaranteed that once he creates, he will be facilitated by the state machinery to earn for himself, to fend for himself. And if we do not have this system, then that will not be an impetus to creativity in the society. That's what we feel. That's what experience has taught us. Of course, there will always be some people who will be creating without any objective of earning from it. But then there's a vast percentage of people who are creators, but who also want to earn, because otherwise they will have to depend upon charity for creation. And that's not a very sustainable model. Now, at the same time, we must make it clear that too much emphasis on ownership and a little emphasis on sharing is also not good. So we need to make a balance between owning and sharing.
Okay, so it's approaching, to end. So if I would have think that this kind of discussion may take much more time, then we will have planned for 2 hours or something. Next time we will see that how we can plan this thing. So it has been a wonderful, discussion from all of you. And I must thank every panelist and including Professor Raman, because he's with me in my faculty. So I must be more thankful to our guest, Professor James and KM Gopakumar. And I must ensure you that you will always be aligned to our further discussions, and we'll be planning something which should be more specific, where we will have certain solutions, certain suggestions specifically to be. So with this, I hope that we will conclude this very webinar, and thank you all. Thank you.
Thank you so much. Thank you.
Thank you.
Gopakumar, are you hearing?
Yeah.
Thanks. Thank you, everybody, and thank you, participants.
Thank you, sir. Thank you. Okay.
Thank you.
Okay.